the records have at least 25 school cases that you were involved in, involving desegregation or busing, and
about 55.
55 cases. See, my information is wrong here, and so I want to kind of look at a few of the cases. I want to pull out a few, and then I want you to, if I didn't pull out any that are especially important to you, I want you to talk about them. And one of them is the Walston versus the Naslund County
Right.
School Board, and then following that the Giles and Franklin County cases. Tell us a little bit about those two cases.
Well, Walston was one of the cases that we held in the Tidewater area. The jurisdictions that we sued in that area included Norfolk, Portsmouth, Chesapeake, Isle of Wight, Suffolk, or Nassau, Newport News, Gloucester. Those districts that I remember. Norfolk was a 19-year project. I described that the other day. Portsmouth was one of those cases that we held during the time that Norfolk was going on. They didn't put up nearly the resistance that Norfolk did. Chesapeake was one that we held while I was doing the Norfolk case. Nansman was one of those cases as well. We had civil rights leaders, for the most part, serving as plaintiffs in those cases. And the lead plaintiff in the Suffolk case was Walston. I mean, the lead plaintiff. We tried to pick someone who was well-known or a leader because they wouldn't be frightened or intimidated by any pressure. By the time we did Walston, we had conditioned the court to grant orders in desegregation cases because of the neighboring cases.
What do you mean conditioned the court?
Well, the first time we tried cases in that area, the judge wouldn't have had that case before or a case like that before. So all of those cases were tried before Walter Hoffman. And so once we won one of them, or two of them, the pattern for deciding them was set, and the pattern for litigating them was set. So Walston wasn't one of the first cases we tried down there. Portsmouth, for example, preceded Nansman or Suffolk. So we had tried 2 or 3 cases down there when that case came up. And the difference in the case involved the number of schools and the particular pattern of schools and the history of the African-American schools and where the black students and black teachers were assigned before desegregation. Well, those were the things that stood out. There was nothing particularly unique about the Walston case, except that it was spread out. Nassau County was spread out over a large area, and so the school districts were done with that configuration in mind. The early cases, we had freedom of choice type solutions, but once we got freedom of choice outlawed, then we got students assigned by districts. As I recall it, Nansman was one where we assigned students by virtue of the districts. And by that time, we had forced the school boards to reassign the teachers so that you wouldn't have a white faculty in one school and a black faculty in another. You'd have faculty desegregation as well. But there wasn't anything particularly noteworthy about the Nansman case as there was some of the other cases. For example, the Giles case, Oh, that was a case where they fired all the black teachers. They closed their formerly black school and fired all the black teachers. And they didn't try to assimilate them into the school district. And so we sued on the basis of faculty desegregation and faculty elimination, and they were ordered to rehire, not to fire the teachers, because you couldn't arbitrarily fire the black teachers. So it stood for the proposition that when you merge a school district, you couldn't eliminate the black teachers per se. And that was a landmark case. That was a leading case on that.
I was wondering, why do you think that Norfolk was so resistant?
Because of the school board. The school board chairman was a political leader, and they had a major law firm defending the case. And because of the housing projects in Norfolk, Young Park and Diggs Park, and they had a lot of housing projects, he had huge numbers of African American students, and they didn't want those students integrated into the system. They didn't want white students assigned to schools where those students were attending. So Norfolk hired an expert to testify on a defensive theory that they came up with called a tipping point. They got a Yale professor who wrote a story saying that once blacks achieved a certain percentage in the district, whites would flee. And so to avoid white flight, you couldn't desegregate the schools beyond a certain point. The problem with that is that somebody had to play God and decide which black students would be relegated to the all-black schools, because they didn't want to mix them in with the others. So who would decide which kids would suffer that fate? So you couldn't do it. So we had that case on the way to the Supreme Court, and a friend of mine, Julius Chambers, had a similar issue in Charlotte-Mecklenburg merged, and both of us tried to get the Supreme Court to take it, and the Charlotte case went up to the Supreme Court. So Swan versus Charlotte-Mecklenburg stood for the proposition that you couldn't use busing to defeat desegregation. You had to transport students in order to desegregate them, and you had to desegregate those schools where you had large numbers of students. And Swan became the precedent, as opposed to Brewer, which was my case. We were friendly competitors as to who had the best law firm in handling cases, and Julius Chambers got the Swan case accepted by the Supreme Court, and Greeks versus Duke Power, the employment case, he got those accepted by the Supreme Court. And but that was the reason why I think Norfolk was so difficult. It raised some issues that the other cases didn't raise. For example, the Norfolk school system tried to make the students pay for their transportation to school, which was a burden on African American children, because there was 5 or 6 children per family in some cases, and the families couldn't afford to pay to transport the students. There were schools right in their neighborhoods, segregated schools. So if you assigned them to a desegregated school and they had to be bused, the case stands for the proposition that the school board had to pay for the busing, for the transportation, and the students didn't have to pay for it. We also got a precedent in the Norfolk case that we are entitled to be compensated out of the fund that was created. If you took the cost of the transportation to the students, it was hundreds of thousands of dollars. So we got a fee for getting transportation to the students. So we had to segregate the case. I think the transportation was 22% of the issue. 22% of the time we spent litigating was devoted to getting transportation for the students. So we took our hours and divided them, and 22% of our hours were responsibility of transportation. So the judge gave us 22% of our fee, of what the fee would have been. So that was something that was unique. We had to take each hour we worked in Norfolk and to say what it was for. And it came out to 22% of the whole. We had our own expert. We drew our own plan to compete with the plan the school board submitted.
So which judge was it who made you do this?
Well, Judge Hoffman was the judge all the time. We had him all the way through the case until the very end when we caught him out of town one day. But he was the judge who ruled on the transportation issue. I mean, not transportation, but on the tipping point issue.
Do you think that he was working along with, in a sense, the white power structure in Norfolk? Or do you think he was just completely removed from that and coming from his own perspective?
I think he was a little bit of both. I think he was, he went along with the theory backed by the power structure, but he was committed to keeping the schools segregated as long as he could. I mean, it was clear to me that that was his motive.
Yeah. Let me ask you, let's stay in Norfolk for just a little bit longer, and let me ask you about the Booker T. Washington High School situation.
Yeah. That was an emotional issue. We ran into that in several large urban school districts. Portsmouth, for example, I.C. Norcom was the African-American school, and in Norfolk, Booker T. Washington was the African-American school. In Portsmouth, we actually almost had race riots. We had, the community was aroused to oppose the school case because we would eliminate Portsmouth as a predominantly black school. And I remember attending a mass rally one Sunday while the case was going on. And Ben Chavis, who was a civil rights leader, was in Portsmouth to charge the crowd. And Chavis had spoken, and he had him worked up to a high anger. And when I walked into the church, I was booed and hissed and everything. And I had to talk to the students to try to calm them down. And, you know, I spoke to them and told them that I appreciate the pride they had in their school, but we're governmental laws, and they couldn't defy the law, and this is what the law required, and this is what I was going to ask for in court. And they kept saying, we want our school. And I said, well, you'll have your school, but it won't be all African American, it will be integrated. And I said, we'll make sure that the facilities will be equal, but we can't preserve a segregated school when we're suing to desegregate schools. And it was pretty heated, but I stood my ground, and you know, they didn't riot, but they were pretty angry.
What were they afraid of?
I think that was something that was going on across the country. The same sentiment existed in Booker T, except that they didn't have a public confrontation. What they did in Norfolk was to get some of the leaders to support their position opposed to what I was doing, what the NAACP Legal Defense Fund was doing. And in the court case, they didn't have a party or anybody advocating their position, but they just had a group of people in the community who wanted to preserve Booker T because of a historical connection it had with the black community.
Yeah, there was a whole controversy about where it should be placed, and even the idea of renaming it. Joe Jordan was opposed to you on that particular thing. So I was wondering if you could talk a little bit about that.
Well, Joe was one of the heroes of the civil rights struggle. He was very heroic and courageous. He was vice mayor of Norfolk, and he was a friend of mine. And he sided with the people who wanted to preserve Booker T. But on this issue, you know, we just disagreed.
What was his argument? What was the basis of his argument?
Well, he never appeared in court. He just supported the African American parents and students who wanted to preserve Booker T. And you know, I don't know what he would have argued in court, but Joe was he was an unsung hero in Norfolk. He fought the gentrification of Norfolk. African Americans were living downtown, and the white community recognized that this area, the housing that they built in this area, was too valuable to leave in the hands of poor black people. So they built housing that only whites or affluent blacks could afford to live in. And Joe, as vice mayor, got them to insist that the people who live there would be given an opportunity for housing before they bring in outsiders. And when the city built the housing, they did not offer the African Americans a chance to live in it. So the people who did live there were affluent African Americans who could afford to live there. And Joe was so angry that they betrayed those people that he resigned. In protest, he resigned from the city council. I later on stayed in one of those houses one summer when I was litigating the case. A doctor who lived across in Isle of Wight somewhere, but owned a home in Ghent, the Ghent area in Norfolk. She rented the house to me. So for 6 weeks I lived in that house, and litigated the case. And it was ironic that that was one of the issues that caused Joe Jordan to resign.
Did the two of you ever talk about your mutual?
No, we would run into each other sometimes in court, in some of the courts in Virginia, but we never really had any conversation about that. I think that was probably one reason why he didn't appear in the case, because of our relationship, because he made no formal appearance in the case, but he represented the parents.
And so this whole controversy over where to place the school and so forth, what was your position? Because you were really representing the NAACP's position. So
yeah. I think that the Justice Department intervened in the case, and the Justice Department came in with a plan that would not have desegregated Norfolk fully. And I walked in the hotel room a night or 2 nights before trial, and the Justice Department presented their plan to me. And I raised hell over it. I said, this is ridiculous. We're going to oppose this. And they said, well, you can't, look bad if you oppose our plan. We're here to help you. I said, well, then if you're going to help me, you're going to draw a different kind of plan. And they scrapped that plan and started another plan and drew a map that satisfied NAACP. They did what they thought was right, but it wouldn't have promoted the maximum desegregation. So we threatened to oppose it, and they backed down. They had an expert named Dr. Foster who lived in Coral Gables, Florida. I remember going down to Coral Gables, meeting with him one time about his plan.
what type of person was he?
Very nice guy. He had a home in Coral Gables, and he entertained me. He was a nice guy.
Mm-hmm.
He was a professor. But he worked in several cases for the Justice Department.
Mm-hmm. Well, now you've in your deliberations in court, you've encountered people like Leonard Davis, who's the school board attorney, Toy Savage, who represented the parents who were opposed to busing. I was wondering, can you tell me a little bit about the dynamics between you and these individuals in and out of court?
Well, Toy Savage was a prominent lawyer in a firm called Wilcox & Savage, and he was the principal litigator for the school board. I was the litigator for the black families and children. And we dueled in court for several years. Each year we would fight the case, and he hired this expert, who's a national known expert from Yale University, and I hired an expert to counter him. And the Justice Department came in, and they had an expert, so it was a highly litigated case, and we ended up prevailing. But the Justice Department was trying to help us, and a couple of times they would run afoul, and we'd have to clash, and they subsequently, reconsidered and went along with our plan.
Explain what you mean by that.
Well, if the Justice Department had a plan they were going to present and offer the court to show that this is what the United States government proposed, we would always convince them not to submit something different from what we wanted, or either to modify that plan or to work together with us so that we could be on the same side. In other words, you were there to help us, so you don't oppose us. And we were always able to work it out. We never went in court taking a position hostile to the Justice Department, or vice versa. They never took a position hostile to us. But there were some times where we worked it out behind closed doors before we got to court, and when we went to court, we were together.
And so, what about Leonard Davis?
He was a backup attorney for the school board. I don't remember him doing too much.
Mm-hmm.
As long as Toy Savage was in the case, he was the lead counsel.
So did you have conversations with either of them outside of the court?
I'm trying to think. I had conversations with the lawyers, but that was just in preparation, anticipation of our position in court. Mm-hmm. Some of the things we were able to work out, but when we couldn't, we had to present them to the court.
What about W.T. Mason, Jr.?
Yeah, he was, I think at that time he was a U.S. attorney. He was a relatively young lawyer who was practicing in Norfolk. And he was involved in the litigation. I think he was probably serving as local counsel for the government, in the school case. He was a well-known attorney. He was in the firm with William Robinson at the time.
And so you all were, of course, in the same bar association, and you frequently saw each other. Did you talk about your cases at any point in time?
Yeah, you mean Mason and I?
Mm-hmm.
Yes, we would talk. And I said we were on the same side. He was representing the government, and I was representing the African-American plaintiffs. And we always ended up on the same side. Sometimes we started off in different paths, but before the case would end, we would be together.
Mm-hmm. What about H. Harold Flannery?
Yeah, he was the chief attorney for the United States Justice Department. Mm-hmm. He was the lead counsel for the government. They had several attorneys. And I was the counsel for the plaintiffs. On one occasion, I had a lawyer from New York working with me. Nathaniel Williams was from the Legal Defense Fund. He and I were counsel for the school board, for the school children.
I'd like to talk a little bit about these other cases, these employment discrimination cases, like the Quarles and versus the Phillip Morris case. Can you tell us a little bit about that? How you got involved and when all that happened?
I was one of the persons who testified before the Congress in support of the Civil Rights Act of '64. One title, there were 10 titles. One title was Title VII, which dealt exclusively with employment discrimination, so I was familiar with that. When Title VII was passed, obviously there was no case right after it was passed, And I got two plaintiffs who worked at Phillip Morris, Douglas Quarles and Ephraim Briggs. We challenged their departmental seniority practice and that practice of paying blacks less than whites for comparable jobs. One provision of the Civil Rights Act required equal pay for equivalent or equal work. And the company had a practice of a cigarette flavoring machine in the fabrication department, that's the manufacturing department, was the same as the flavoring machine in the non-manufacturing department. But they paid the worker who operated the machine in the manufacturing department $1 and some cents more per hour than the one in the prefab department. They favored tobacco in the prefab when they were handling the leaf tobacco, which was dirtier work. And then they flavored it again when on the tobacco machines, which was cleaner work. So the Briggs was operating the prefab machines in the flavor machine in the prefab department. So we sued, saying that he was denied equal pay from the person operating the machine in the manufacturing department. The machines had different names, but they had equivalent to the same function, and the court agreed, and Phillip Morris was held guilty of violating the equal pay provision of the Title VII. Quarles was in the prefab department working, and he applied for a job in the fabrication department, manufacturing department. In order to get the job, he would lose his seniority. The court found that the entry-level provisions were the same for both departments. So they had no reason to deny the person who transferred the seniority except as to preserve the discrimination. So the court outlawed departmental seniority systems, which applied in all kinds of companies where you, in order to transfer, you had to lose your seniority. That was a major victory for Title VII, and was the first decision on the merits in this country implementing Title VII. There were other decisions involving class actions, where you had the right to bring a class action and all these preliminary questions. But to get through all those questions, to get to the merits, you had to negotiate a whole lot of other obstacles. So the name of the case was Quarles versus Phillip Morris. Later on, the Phillip Morris officials thanked me for assisting them in carrying out the law, because they discovered a huge reservoir of African American employees and management and otherwise that previously hadn't been unavailable to them because of this court case.
That was a massive case.
Yes.
And how did you and your firm handle such a huge workload?
We had the assistance of attorneys provided by the NAACP Legal Defense Fund. They were attorneys from New York who came and assisted us. I was the lead counsel in the case, but the other lawyers helped assisted us in carrying out the case and arguing the case. The case went up to the Fourth Circuit, and but it was a big victory. Another case, Patterson versus American Tobacco, was another class action case, and that case stood for another proposition. It was a class action, and we got hundreds of thousands of dollars for African American employees in the tobacco situation. But the issue was, what do you do with a white who had been put into a position and a black that should have gone to the black? And the court found that the black should be entitled to the position. Do you remove the white from the position? Because he didn't do anything wrong. He was assigned a position, he was qualified for it, but he was put in place of a black who should have gotten it and had more seniority. I asked the court to bump the white employee from the position because he had no business there. It should have been the black employee's position. And the court said that that was not in accordance with the spirit of Title VII. They would leave the white in the position, but they would provide that employee front pay. And front pay was a concept where they would pay the black until a vacancy occurred in that position because the positions weren't static. And he would get front pay. And that was a new concept because we knew what back pay was. If you were denied a position and you got back pay, you'd be paid up until the time you got the position. Front pay was if you're entitled to get a position, but an innocent person was in the position, you'd be paid until that position became available. And Qualls versus Phillip Morris stood for the proposition of front pay when they went up to the Fourth Circuit. And I asked that the white employee be bumped and the black be put in position. And the court denied that, but granted me front pay, which was novel. And that became a remedy that was available throughout the land in Title VII.
Now, in conjunction with the front pay, was the individual also given, I would say, the years of service in a management position as a...
Well, no, here's what would happen. If the employee was denied the position, say for 2 years, and the case came to court, he would get the 2 years back pay. But if there was a white in the position, he wouldn't be removed, the white wouldn't be removed from the position. The white would stay in the position. And the employee would be sort of red circle, kept paid as though he was in the position until the vacancy became open. Then he would get in a position. So that was, he'd get back pay and then he'd get front pay until he got the position.
Okay, okay.
It's a novel concept.
Yeah. What about the case of Gravely versus Robb?
That was interesting. We had handled redistricting cases before. I guess I'm one of the few attorneys, maybe the only one, who handled a redistricting case growing out of the 1960 census and handling a redistricting case going out of the 1970 census and handling a redistricting case going out of the 1980 census and handling a redistricting case going out of the 1990 census. And Gravely versus Robb was going out of the 1980 census. The General Assembly had a practice of having multi-member districts. They would take for example, a city like Richmond and combine it with surrounding county, mostly white like Henrico, and they would have elect 6 or 8 people from Richmond and Henrico, which was a way of diluting the impact of the African American vote. Well, Gravely versus Robb established a proposition that the state had to carve single-member districts, and so the state was divided into 40 districts for the Senate, because there are 40 senators, and now I serve in one of those districts. But it was a 3-judge court case in federal court that established a proposition that they couldn't have multi-member districts anymore. Each Senate district had to be contiguous, and each House district had to be contiguous. It was an important case because it changed the political dynamic in the legislature.
Were these kinds of cases part and parcel of an overall strategy?
We were, Mr. Tucker and I really were cooperating attorneys, and with the Legal Defense Fund. They have a network of cooperating attorneys all over the country. Unlike the other cooperating attorneys, we would handle our own cases. In most of the situations, the cooperating attorneys were local lawyers who did a lot of things, but they didn't specialize in civil rights. So they would send somebody there from New York. They had a team of about 20 lawyers to litigate the cases, and the cooperating attorneys would serve as local counsel. In our case, we would litigate our own cases. They argued them. When the case got to the Supreme Court, I argued some, Mr. Tucker argued some. We argued our own cases in the Supreme Court. Now, there were cases, sometimes we'd let the Legal Defense Fund lawyer argue, but most of the time we'd argue our own cases. So we had a unique relationship with the NAACP Legal Defense Fund.
Mm-hmm. Well, that brings me to my next question. I'd like you to talk about your law partner. I know that he liked to be called S.W. Tucker, but it was Samuel Wilbert Tucker.
Right.
Tell me about him. You both graduated from Howard University Law School, but that's not where you met. He was older. So tell me a little bit about this
Well,
man.
Mr. Hill had influenced me to join him while I was in college. He had offered me a position. So when I came to join him, he introduced me to S.W. Tucker, who had worked with him for over the years, and he had agreed to bring Mr. Tucker in as his partner. He also brought me in. So the three of us met in the offices in the Southern Aid building. And he said, Tucker and I were going to get together, but you can join us. He said, but I found out from President Kennedy that I'm going to have to leave in a week. I can't practice law. So I'm going to have to turn the practice over to you fellows, and I'll be back, but I'm going to let y'all run the firm. So Mr. Tucker and I met, and we shook hands on a partnership. Now, he'd been practicing 20 years, and I was just getting started. And he said, well, Henry, I got to practice and employ you, and I'll be making some money off of that, but you got a family here, you're married, you got a family. How are you going to survive? You need to have a salary. I said, no, I'll earn my way. So let's see how it goes for a while, because I figured I'd be better off if I became a partner rather than being paid a salary. So after 2 or 3 months, we started making some money, and we formed a partnership. So I started off really as a partner in the firm, and the firm was known as Tucker and Marsh. And it stayed that way until Mr. Hill returned 5 years later, and we named it Hill, Tucker and Marsh. But I started off in the firm as a partner, and before Mr. Hill returned, my brother was hired. So when he got back, we had other lawyers. As soon as Mr. Hill got back, we hired some more lawyers, and we eventually got up to 13 lawyers.
So tell me about Mr. Tucker.
He was an amazing lawyer. He never went to law school. He was at Howard with Mr. Hill, and they met and they were friends. And when Mr. Tucker took the bar before going to law school, and Mr. Hill had gone to law school, and they both passed the bar. Mr. Tucker had to wait because he wasn't 21. He read law, and he was 19 or 20. He couldn't start practicing until he was 21. But he had a tremendous legal mind, the most astute legal mind I've ever encountered from anybody. And his mind was like a computer. He just knew the law, and he was an amazing person. Judges used to call him and ask him questions about problems they couldn't resolve. And he was a tremendous litigator and a brilliant appellate lawyer. He had a way of going right straight to the argument and disregarding all of the fluff and going right straight to the argument on the appeal, which made him devastating. He very rarely lost an appellate argument. And he was a brilliant brief writer. He wrote briefs for appeal because he was so concise. And he was an amazing person. The law was his whole life. He was the chairman of the legal staff. And then Mr. Hill left. He turned the chairmanship over to Mr. Tucker. And we worked together for 20-some years, and he taught me how to practice law and taught me everything.
What were some of the things that he taught you?
Well, how to litigate a case, how to write a brief, how to interview a client. I mean, everything. He was my mentor, and he'd been practicing 20 years. He knew.
So what were some of the things that he would tell you, such as how to litigate a case?
Well, I would watch him first, and I would imitate him. I would watch him. He was a brilliant cross-examiner. He prepared his case. He believed in preparation. He researched the case. He was very thorough. And he would, his mind was like a trap. He would he would question the witness in such a way that he would set a trap for him. And he'd ask the question, so whichever way he answered, Mr. Tucker would get the answer he wanted. And he was brilliant. And he worked hard. We worked at night. The two of us were going up against private law firms, which these law firms on Main Street, plus the Attorney General in some cases. In our school cases, we went against the Attorney General's office. In some cases, we had the Attorney General and a private law firm. McGuire Woods, or Hunton Williams, or Mays Valentine. And we would beat them all the time. I mean, we would prevail. I remember one situation right after I started practicing where the General Assembly would summons civil rights supporters to the General Assembly and question them, trying to see if they were communists and trying to see if they were violating the laws. And Mr. Tucker and I would represent them. And he was fearless. I mean, none of these people were ever, they were harassed, but none of these people were ever discouraged from supporting ACP.
Were the two of you ever attacked by this commission?
Mr. Tucker was, they tried to disbar him. When I first came to the firm, they had a disbarment proceeding against him. And that was dismissed, and they had another one. He had a trial, and I participated in the trial with a bunch of other lawyers who, from around the country, who came to help defend Mr. Tucker. And there was a meeting with about 10 lawyers, Bob Carter from New York, Herb Reed from Washington, Spot Robinson, Thurgood Marshall, Charlie Duncan, all the great, Bob Ming from Chicago, all the great lawyers assembled to try to defend Mr. Tucker. And Mr. Tucker was told that this case is brought in Southside Virginia, where the judges are very conservative and hostile. So you have to get a white lawyer on your team because that'll give you a better chance. Mr. Tucker said, oh, no. Said, that would defeat everything I stand for. If I have to have a white lawyer to get acquitted, exonerated, I'd rather not be exonerated. And he insisted that one of the African-American lawyers would defend him. And Attorney Bob Ming of Chicago was selected, and he defended him, and Mr. Tucker was exonerated. I mean, Bob Ming was brilliant. He was brilliant. It was a courtroom packed full of lawyers and residents of Greenfield County. And Mr. Ming, Bob Ming, not only did he win the case, but he whipped the Commerce attorney so bad that I almost felt sorry for him. I mean, Bob Ming embarrassed the Commerce attorney.
Explain how.
He would make an objection about hearsay, and Bob Ming would recite the origin of the rule from British law, the rationale for the rule, and show how the court should rule in his favor. And he got every ruling right. I mean, he knew so much more than the judge and the other side on every question he raised. And then in his closing argument, he got up and said, the wrong man is on trial here. He said, Mr. Tucker is charged for unethical conduct for representing a poor person who is seeking his constitutional rights. He said, that is the highest calling of any lawyer. And he said, Mr. Townsend could select anything from the range of punishment, from a warning to a private reprimand, to a public reprimand, to a suspension, to a disbarment. He chose capital punishment for a lawyer, disbarment, the highest punishment he could choose, punishing a lawyer for doing the most honorable thing a lawyer can do. He said, the wrong man is on trial. Mr. Townsend should be on trial. Oh, it was awesome. It was awesome. And I thought about Mr. Tucker's warning that if he had to have a white lawyer represent him, he'd rather be disbarred. And no one in the country could have done a better job than Bob Ming in representing him. So that was the most amazing legal performance I think I'd ever witnessed. And when it was over, I went up to Mr. Tucker and I said, you know, Sam, I have to give it to him. He did almost as good as you could have done. He said, Henry, I know you mean it as a compliment. But that was a brilliant performance. It told me something about Mr. Tucker. And when I first started, he said, Henry, you might not want to be stuck with me because they're trying to put me out of business. And if I said, oh no, this is what I want to do. And that's the way he was. And it was amazing.
Did you ever go up with Mr. Tucker to any of these? Like he went up to the Senate Judiciary Committee hearing under Nixon.
Yeah.
Did you attend that?
Oh yeah, we were partners in everything we did. We opposed Judge Hainsworth for the Fourth Circuit, and for the Supreme Court. He was a Fourth Circuit Chief Judge, and we defeated Judge Hainsworth. We testified against him.
Why did you oppose Hainsworth?
Oh, he was very conservative. He said the poor, he wrote in his opinion, I forgot the quote now, but it was something to the effect that the poor would always be with us, and it was very disparaging about poor people and about people who were denied their rights. And we opposed Judge Bork, who was nominated by Nixon. We were successful in all these attempts to defeat these. Judge Coswell, and both of us went up to participate in those. The one time, Mr. Hill and I disagreed when Lewis Powell was put up for the Supreme Court. The NAACP made a calculated decision that although Lewis Powell wasn't all that good, he wasn't all that bad, and if Powell was rejected, the next person we get wouldn't be nearly as good, so they supported Mr. Powell. And Mr. Hill, who had been a close friend of Mr. Powell, supported him. I opposed him because I felt he had waged war on the Constitution. And so that was one time where Mr. Hill was on one side, being the primary speaker for Lewis Powell, and I was on the other side with Congressman from Michigan who testified. He and I were the only two people who testified. He's now chairman of the Judiciary Committee, Conyers. Congressman Conyers and I testified against Powell. Of course, he was confirmed. And Mr. Powell, Justice Powell, never got over the fact that we opposed him, especially me. He didn't mind Conyers, I guess, because Conyers was very liberal. But for me to oppose him sort of hurt him. And he talked to me later about that, at the judicial conference. He asked me, why did I oppose him? I said, because you waged war on the Constitution. You took an oath to uphold the Constitution, and you served as chairman of the Richmond School Board when they fought the desegregation of the schools. And you served as chairman of the State Board after you took an oath there when they administered a tuition grant program, sending public funds to private schools that would segregate to avoid desegregation of the schools. I said that was lawless conduct, and I understand you have some tremendous credentials, but I just don't think you should be on the Supreme Court.
What was his response to
He
that?
looked very disappointed and hurt. But, I had to call him like I saw him, and I said Mr. Hill and I just didn't agree. Mr. Hill said that even though he was wrong, he was better than the other people of his time. He, when he spoke in favor of desegregation, the other people tried to shut him down, and Lewis Powell said, no, let's let him speak, and that was very gentlemanly of him, but he still, had no business opposing the Constitution. He wanted to be on the Supreme Court. Mm-hmm. So that was one other time when Virginia was trying to avoid being covered by the Voting Rights Act. Mr. Tucker and W. Lester Banks, the executive secretary of the NCP, and I went up to Washington, and there were hearings before the House committee and the Senate committee. So Mr. Tucker and W. Lester Banks went to the House committee, and I went to cover the Senate committee because we didn't know how the thing was going to come out. And Harold Washington was in the Congress, in the House, and Teddy Kennedy was in the Senate committee. So in the morning, when the Attorney General, Acting Attorney General Gray, testified that Virginia shouldn't be on that because they hadn't done anything wrong. And we had anticipated that, so I was armed with a decision in a case that we had handled from Petersburg, enjoining Petersburg from using the blank registration form. What the registrars would do would be to give you a blank piece of paper, and you had to memorize the 10 questions in sequence and the 10 answers in sequence. You had to write it out. If you couldn't do that, you couldn't register. So, of course, the Voting Rights Act, you couldn't use a literacy test at all. So even if you were illiterate, they had to let you vote. Here was a test that you had to memorize the questions and the answers and write them out. So when the Attorney General argued in the morning session that Virginia had not violated the act, they shouldn't, even though the people didn't vote, since Virginia hadn't done anything wrong, we shouldn't be included in the act. And when they broke for lunch, I interrupted Senator Kennedy, Teddy Kennedy, in the hall. And I said, Senator Kennedy, I heard the Attorney General this morning. Here's a court order that we got in Petersburg last month, which refutes everything he said. And he said, thank you. This is all I need. And he went on to lunch. When he came back after lunch, he recalled Mr. Gray. He had that order in his hands, and he whipped him to death with it. He said, what does it mean that the judge said that the registrar has been using this form, and this is what he is doing, and he's now enjoined from doing this permanently? And Mr. Gray was caught by surprise. He tried to explain it. And Kennedy whipped him to death. He beat him. He said, how dare you stand before this committee under oath and tell us that the state hadn't violated any laws when you require black citizens to memorize the questions and the answers? He said, look at these questions. Next president, the jobs you held. He said, I don't know what that means. How could a voter know? I mean, he just read. And Virginia was included in the act. And the irony was that Mr. Kennedy was a senator, and here's this black youngster, because at that time I looked like a youngster, stopping him in the hall, giving him something, talking to him, and he took it and used it and went on to his lunch, and I went on to lunch and came back, and he was smart enough to understand it and whip him to death. It was just amazing. A very successful experience. So I became a fan of Teddy Kennedy. That was before Chappaquiddick, before his brothers had been assassinated. And I met him later at a cocktail party, and he had all this bulletproof vest on. And my hand accidentally touched him. It was like hitting a piece of metal, because they were afraid somebody was going to assassinate him. You know, he had all this stuff on. And I reminded him of that chance meeting. And he remembered that.
Did he?
Mm-hmm. So that was a unique experience for me as a young lawyer, having that experience.
Yeah. Did you encounter other politicians, not only through your involvement with Mr. Tucker, but also with these cases that you litigated? And I'm thinking of especially some of them here in Virginia.
No, I knew of Lindsey Almond and his relationship with Mr. Hill, and I knew of that, but I dealt with other politicians because of my role as elected official. I was president of what they call ABC-LEO, the National Black Caucus of Local Elected Officials, all local elected officials in the country. Coleman Young, Maynard Jackson, Tom Bradley, all these local elected officials. I was vice mayor, but I was the president of all the local elected officials because I was very active as a vice mayor. And then when I got to be a mayor, I was chairman of one of the standing committees of the U.S. Conference of Mayors. There are 4 standing committees. And those 4 positions provide the leadership for the U.S. Conference of Mayors. I was chair of the Committee on Arts and Culture. So I knew almost all the elected officials. And I was an early Carter supporter, so I was a liaison with the Carter administration. And so that helped me. Some of the mayors were in Carter's cabinet. So when I wanted to stop the state from building a circle around Richmond, the mayor was Neil Goldsmith, mayor I knew from Portland. And I went to him and got him to hold up the circumferential for 3 or 4 years because it was create sprawl away from the center city. And that was a concept that these people didn't know anything about, and the highway department didn't know anything about, really. But because of my connection, political connection, I was able to do that. And finally, Neil came to me and said, Henry, I've held this thing up for 3 years. You better get what you can get because they couldn't put so much pressure on me, I'm gonna have to let it go. So what we did was we reduced the number of outlets because the development would occur around a highway outlet where you have an interchange. We reduced the number of interchanges in half, and we got protection for some of the historical sites in the area. And we got a bypass signage so that people traveling north-south would know that they could go around or they could go through the city. They had a choice about 15 or 20 miles before they got to the place. And that kept some of the tourism, north-south traffic, coming through the city rather than going around the city. They could, when they got coming from Washington, they could go around and come back, or they could come straight through, or they could go around Charlottesville way. So, you know, I got those things. But that was because of my political connections.
How did you see your role in this effort that's taken up so much of your life?
It's a good question. I don't know. I got into it by accident. I looked in the paper and saw that Virginia was having a hearing on how to frustrate desegregation. And I went down to testify. And I made like the students sent me down, but I went on my own. And I met Mr. Hill. And when I heard him speak, and he spoke on behalf of the legal staff, and other members spoke, but he was the keynote, and he shook his fist at those people. And that shocked me. And he spoke with such power and force and sincerity that I knew that I wanted to be a part of that movement. And that's when I decided I was going to be a lawyer. And afterwards, he met me and told me that, what you going to do? I said, I'm going to be a lawyer. Like he said, well, why don't you come work with me? And I was a college senior. Hadn't gone to law school, hadn't been admitted to law school. And he gave me a job. And I said, that man, that great, would give me a job and I haven't finished law school? So when I went to law school, I was motivated. I mean, the fellows would go out on the weekend to date people in D.C., you know, I think it was 6 women to every man in D.C., and they were after these future lawyers and future doctors. I stayed in the dorm and studied on the weekend, all night, burning, because I wanted to be a lawyer. And when I joined Mr. Hill and Mr. Tucker it became a part. That was what I wanted to do. That was my life. And I devoted my life to it. And I had no idea going into politics. But the law was so slow, I figured somebody needed to go into politics. So I went and couldn't get anybody else. So I ran the first time to give me 2 years to get somebody. And that 2 years turned into 25 before I realized what happened. While I was still litigating all these cases and everything I was doing, at the same time I was involved in the political thing. Being president of NBC Leo, I was going on both tracks and raising a family. So I had a busy, happy life. And then Governor Wallace called me over one time and said, look, you ought to be over here in the General Assembly. And I was persuaded to come over there. And I've been on there 17 years, and I'm now chairman of a major committee, the Capital Budget Committee, responsible for all the building program in the state, chairman of the Courts and Justice Committee, still litigating, and amateur golfer. So I have a full life and a happy life. I've always enjoyed everything I've done. And while I'm still young, I'm going to find something else to do while I continue what I'm doing. But I've been lucky. I've been at the right place at the right time, and I'm associated with good people. And, you know, I'm sure before I fully grow up, I'll find some more enjoyable things to do.
So you see your life and your experiences as a set of situations that coincidentally happened, but you were there to say yes to a lot of things.
Yeah, I didn't have to go over to testify. And it was risky to go over to testify, but it was something I wanted to do. And that's how I hooked up with Mr. Hill. And the rest of it sort of flowed. You know, I didn't have to run for office. But I woke up one morning and heard the guys who had been selected to run to say that the doors of opportunity have been open. All we got to do is prepare ourselves. And I knew that wasn't true because I was suing everybody to open the doors. So I started running around trying to get someone else to run who would speak truthfully about their situation. And when I couldn't get anybody else, I said, well, I'll run for 2 years. I was still litigating all over the state. And at 2 years, once I got in there, I couldn't turn it loose. And, you know, at my first meeting of council, I saw how weak those people were who I'd always looked up to. I'd been appearing before them for 5 years representing citizens. And I looked up to them as great people. And once I got in the room and saw how shallow their thinking was, I said, I could do a better job than this. And the next meeting, I went out, formed a team to try to take them over. And 2 years later, when I ran again, I was the head of a team of 5 people to take control of the 9-member council. We missed, but we came close. And after the next try, they annexed right quick to keep us from taking over. We would have taken over. So that's how I got started. I never stopped litigating, but I had this political thing going at the same time. So I've had a happy, full life so far.
If you could isolate one person who has really been your inspiration, who would that be? And why?
It'd be 3 people. My father, because he set an example for me and the others. He worked 12 hours a night while he was in school, while we were in school. Mr. Hill, who opened my eyes to what I wanted to do, and Mr. Tucker, who trained me and who was my role model. All 3 of them are the people who meant most to me.